Welcome to the Deep Dive. Today, we're plunging into a topic that isn't just academic. It's really fundamentally shaped our world, and, well, it continues to be a battleground for human dignity: the prohibition of racial discrimination.
Absolutely.
Just think about this historical reality. When European colonial powers met at the Conference of Berlin in 1885 to, well, carve up Africa, they were literally drawing lines on maps of places they didn't live, often with, no real understanding or regard for the people already there.
And it wasn't just a land grab, was it?
No, exactly. It was built on and justified by these profoundly discriminatory racial ideologies, ideas that position non-Europeans as inherently inferior, basically justifying their subjugation, their dispossession.
That historical backdrop it's absolutely essential for understanding the modern legal frameworks we have today. It really highlights the sheer scale of the problem that international law eventually had to confront.
So we're going to take a deep dive into this crucial human rights issue, and we're using a comprehensive stack of materials made available by the University of London for educational purposes.
Yes, these sources provide an incredibly thorough look at the topic. They're really excellent.
And we absolutely want to explicitly acknowledge and thank the University of London for making these fantastic resources available. Our whole exploration today is built on these educational materials designed to give you, the listener, a really robust understanding.
And a thank you also to Sinorbit Academy in Sri Lanka for bringing this deep dive to you.
Yes, thank you, Sinorbit Academy. And to all of you listening who might be engaging with this material, perhaps as part of your exam preparation, we really wish you the very best of luck.
Definitely. Good luck.
Our mission today is to help you go beyond just a surface-level understanding. We want to extract the key insights, the nuances from these sources so you feel truly prepared.
Exactly. Our goal is to guide you through this material. We'll unpack the historical roots of racial discrimination. We'll explore the central international legal framework, that's the International Convention, on the elimination of all forms of racial discrimination, usually called ICERD.
ICERD, right.
We'll delve into how that framework operates, how it's applied today, and pay particular attention to how it and related instruments address the specific and critical area of the rights of indigenous peoples.
And we're committed to making sure we cover all the significant points highlighted in the source material, giving you that thorough grasp needed for educational purposes, including, of course, exam readiness.
Think of us as navigators through this important topic.
Yeah, I'll be here maybe highlighting points that jump out or raise questions, while my colleague helps us understand the deeper legal context and, the significance.
Okay, let's begin this deep dive.
Let's start where the sources suggest, with those deep historical roots. The foundational argument is that to really get anti-discrimination law, you first have to understand the world it came from. A world shaped, overwhelmingly, by discriminatory colonial empires.
Right. It wasn't just some abstract idea. It was a system of domination built explicitly on these, well, harmful racial ideologies.
And history gives us plenty of evidence. The European project of exploiting Africa, for instance, it wasn't static, was it? It evolved through phases.
That's right. You have the initial contacts, resource exploitation from maybe the 16th to 18th centuries, heavily driven by the slave trade.
Then the 19th century saw more European presence, explorers, missionaries, treaties being signed, often with zero understanding of local politics or land rights.
Which then culminates in the formal scramble for Africa, late 19th, early 20th century. European powers establishing direct rule.
And that Conference of Berlin in 1885. It wasn't just drawing lines. It was European powers recognizing each other's claims based on this idea of effective occupation, basically solidifying a global order based on European dominance over non-Europeans.
And what's fascinating and frankly deeply disturbing is how this discriminatory mindset got codified, baked right into the foundations of what became modern international law.
How so?
Early European public law, which international law grew out of, created a hierarchy. It distinguished between, quote, civilized nations, which basically meant European states,
Right.
then barbarians, maybe some non-European empires they could sort of deal with, and then savages.
Savages, that's a shocking term.
It is, and it was primarily applied to African-American, Australian, indigenous populations. They were deemed incapable of civilization, and the consequence,
Dark.
savages could be colonized. Their lands, their political structures, their rights, simply not recognized.
Oh.
Even today, if you look at the statute of the International Court of Justice, Article 38, it still refers to sources of law, including general principles of law recognized by civilized nations, a historical echo.
A really clear example of that worldview in action has to be the Treaty of Tordesillas back in 1494.
Ah, yes, Tordesillas.
Portugal and Castile, basically blessed by a papal bull, just presumed to divide the entire non-European world between them. Lands west of a line in the Atlantic went to Castile, paving the way for Spanish colonization in the Americas.
And everything east went to Portugal, fueling their expansion around Africa into Asia.
The sheer audacity. Two European powers dividing territories they didn't own, inhabited by millions whose existence and rights were just, disregarded, deemed irrelevant.
Exactly. It was a direct precursor to later colonization based on discovering and claiming empty or uncivilized lands.
And this historical reality, it really challenges that often cited narrative of a civilizing mission, doesn't it?
It does, forcefully. While some individuals, like Kipling with his White Man's Burden poem, might have genuinely believed they were bringing progress or salvation.
The source material argues pretty strongly that this narrative was often just a mask.
Yes, it was frequently fervent, sometimes violent evangelism trying to save indigenous populations, but fundamentally tied to economic exploitation. The drive for resources, labor, markets. It led to the widespread annihilation of peoples and cultures, not for their benefit, but for the profit and power of the colonial states.
And within these colonial systems, the legal structures were highly unequal. The source talks about dualistic systems of law.
Right. One set of laws for the colonizers, typically reflecting the European home country system, and a different set, often based on a colonial interpretation of customary or religious law, applied to the natives or subjects.
Will you give an example?
A really insightful one from the source is British rule in the Asian subcontinent. The British applied what they perceived or codified as Muslim or Hindu personal law for things like marriage, inheritance.
But Western law for commerce or crime.
Exactly. And the striking thing is, much of what's now considered Muslim family law in modern India, Pakistan, Bangladesh isn't purely historical Islamic practice. It's actually a product of British colonial codification, an outsider trying to systematize local norms, often for control, and changing them in the process.
So it wasn't just administrative convenience, it was a deliberate strategy to maintain power.
Precisely. Mahmoud Mamdani, in his really important work, Citizen and Subject, analyzed this. He showed how colonial law, especially through things like indirect rule, actively ensured the subordinate status of colonial subjects compared to the citizens, the European colonists.
Indirect rule, governing through local leaders.
Yes, but co-opting them into a structure that guaranteed the subjects' lower legal and political status. It was a system designed to control huge populations with few Europeans by embedding racial and political inferiority right into the governance structure.
The era of formal colonialism largely ended after World War II, didn't it?
It did. A complex process. Weakened European powers, the new UN providing a platform to challenge empire, the USA promoting decolonization, often for its own geopolitical aims.
And crucially, the liberation struggles waged by colonized peoples themselves.
Absolutely. And while human rights ideals became part of the conversation later, the source notes that initially, ideologies like nationalism, the desire for independent nation-state, and socialism, linked to anti-imperialism, were arguably stronger drivers for independence movements at that specific moment than human rights frameworks were.
So the end of formal empire didn't just erase racial discrimination. The fight continued, just in different forms, like apartheid.
Apartheid, yes, meaning separateness or segregation in Afrikaners, a brutal system of institutionalized racial segregation and discrimination in South Africa from 1948 to 1994.
And similar systems existed elsewhere.
Similar, though maybe not identical, systems of segregation existed, notably in southern Rhodesia, now Zimbabwe, until 1980, and significantly within the United States.
The source material also mentions the comparison sometimes drawn between contemporary Israeli policies in the occupied Palestinian territories and apartheid.
Yes, it does mention that comparison, citing former U.S. President Jimmy Carter's book, Palestine, Peace, Not Apartheid. It's crucial to note, as the source does, that Israel strongly contests this comparison. We're simply reporting the content, as presented in the source material, maintaining strict impartiality on this very sensitive issue.
Understood. Turning back to the U.S., its civil liberties struggle is fundamentally tied to its long, painful history of racism, connecting right back to the slave trade and early colonialism.
Yes, and some scholars, like Derek Bell, make a powerful, though challenging argument that the USA is, at its very foundation, based on racism.
That's a very strong claim. How does Bell argue that?
Bell, as discussed in the source, suggests the original compromise that allowed the American constitutional government to form in 1787 was essentially keeping slavery. Economic interests tied to slavery were prioritized over the freedom and humanity of black people.
And he argues this pattern continued.
He argues it wasn't just a historical starting point, but a continuing pattern. From the Civil War onwards, Bell suggests any progress for black people has often been met with a white backlash. The deep roots of racism mean black rights and interests have consistently been compromised when they clash with dominant economic or social interests.
That's a stark interpretation. The source applies this to historical
And
periods.
it does. It looks at the first Reconstruction after the Civil War, 1865 to 1877. Formal equality was pursued, put into law briefly but ultimately undermined, leading to Jim Crow segregation. Bell's argument implies the 20th century civil rights movement followed a similar path, achieved formal legal equality but faced persistent structural barriers and backlash limiting real change.
Still, the dismantling of formal segregation in the U.S. in the mid-20th century was a huge achievement, driven largely by intense activism and legal strategies.
Absolutely. The source highlights the critical role of litigation, especially by the National Association for the Advancement of Colored People, the NAACP. Let's remember the NAACP.
They used the U.S. legal system and constitutional rights to challenge discriminatory laws in court.
Yes. While international human rights ideas were growing globally, the main levers used in the U.S. struggle were initially domestic legal and political ones.
American anti-discrimination law evolved in phases, didn't it?
It did. A landmark in the first phase, say 1954 or 1965, was the Supreme Court decision in Brown v. Board of Education. That's Brown v. Board of Education, 1954.
The school segregation case.
Exactly. It declared state-sponsored segregation in public schools unconstitutional. The beginning of the end for de jure segregation in education.
Then a second phase started looking beyond just formal separation, at substantive disadvantage.
Right. The source highlights Griggs v. Duke Power Co. in 1971. That's Griggs v. Duke Power Co. This Supreme Court case dealt with workplace discrimination under the Civil Rights Act of 1964.
And it widened the definition of discrimination.
It did. The court said discrimination included practices with a discriminatory effect, even without explicit intent. This was huge. It effectively encouraged employers to adopt positive discrimination or affirmative action measures to tackle systemic disadvantage.
But that progress faced reversals after around 1974.
Yes, the source points that out. The arguments started gaining ground that, well, formal segregation was gone, the problem was solved, and vigorous positive discrimination wasn't needed anymore, maybe it wasn't even fair.
Opponents argued affirmative action itself was discriminatory.
Exactly. That it violated the 14th Amendment's Equal Protection Clause.
And we see the legacy of that in recent court cases.
We do. The source cites the 2014 decision Schwett v. Coalition to defend affirmative action. Let's repeat that. Schwett v. Coalition to defend affirmative action. The Supreme Court upheld state bans on using affirmative action in public university admissions. It shows the ongoing legal battle over how to address the effects of past discrimination.
Given this complex history, the source suggests we need to look beyond a simple "we shall overcome" narrative. The idea of a straight line from slavery to equality.
Right. That mainstream narrative, while acknowledging progress, can sometimes sideline other views, including what the source calls the Black nationalist critique.
What does that critique involve?
It's associated with figures like Malcolm X, the Nation of Islam, the Black Panthers. As described in the source, this critique, in its most direct form, suggests true acceptance and integration for Black people in America are basically impossible within existing structures.
So alternatives like secession or resistance are seen as better paths.
Yes, preferable or necessary responses. It challenges the very idea that integration into the existing society is the goal, or even achievable.
It's a fundamental challenge.
It is. Kimberly Crenshaw, cited in the source, suggests the militant demand for a separate Black homeland, while controversial, can be read symbolically as an assertion that race consciousness has made African Americans a distinct social community, like a nation.
And Derek Bell again.
Derek Bell offers that stark view. America is a white country, which means that flourishing Black institutions of any kind are unnatural, suspect, and not to be encouraged. These viewpoints are presented impartially in the source as part of the ongoing debate.
And the fight against racism is far from over in the U.S. Contemporary events show that.
Absolutely. The emergence of the Black Lives Matter movement in 2012 after Trayvon Martin's shooting and George Zimmerman's acquittal highlighted ongoing issues of racial injustice, police brutality.
And the political landscape often reflects or even amplifies racial tensions.
Yes, the source notes Donald Trump's rhetoric, particularly about Muslims and Mexicans, illustrating how targets and forms of racism change, often intersecting with immigration and national identity. Racism adapts,
It does, though it's also crucial, as the source notes, to acknowledge the historic election and re-election of the first black president, Barack Obama, a major milestone.
A significant milestone. The source also cautions against seeing racism just as white on black. Hostility can exist between different groups, but it concludes this section by saying the 50-60s civil rights struggle was successful in dismantling the most overt, legally enforced segregation.
Okay, so that first section gave us that vital historical context: colonialism, apartheid, the complex U.S. struggle. Anti-discrimination is about fighting denial of rights and lesser rights based on race. And other ideologies like nationalism were also key early on.
And this history is the critical backdrop for the international legal instruments, which brings us to the core framework, the International Convention on the Elimination of All Forms of Racial Discrimination, ICERD.
ICERD came into force January 1969, and the source stresses its significance. It predates the big 1966 covenants, the ICCPR and ICSKR, and the Women's Convention, making ICERD the first core UN human rights treaty. That's key. ICERD, first UN human rights treaty.
And its committee, the Committee on the Elimination of Racial Discrimination, is the longest established UN treaty body.
It was clearly a product of its time, wasn't it?
Undeniably. Born right out of the global fight against colonialism, segregation, apartheid, it explicitly countered those outdated, dangerous racial ideologies we discussed, the civilizing mission, figures like Lugard. It was a direct challenge to that racist worldview.
At its heart, it affirms dignity and equality for all humans, linked to equal protection by law from discrimination and incitement to discrimination.
Exactly. Its purpose was to mobilize international opinion and legal duties against racial discrimination and policies based on racial superiority, apartheid, segregation, state-sponsored separation.
So let's look at Article 1, the definition of racial discrimination.
It's a broad definition, captures various forms: any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin. Those are the grounds.
And it's discrimination if it has the purpose or effect of harming rights enjoyment.
Precisely. Purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in basically any area of public life. That purpose or effect part is crucial. It means it's not just about intent, it's also about the impact, even if unintended.
Okay. Now, Article 1 has some caveats, right, about citizens and non-citizens.
Yes, it clarifies that state distinctions between citizens and non-citizens are generally not covered, nor are laws on nationality or citizenship unless they are racially discriminatory in how they're applied. So states can have different rules, but not based on race.
And it also addresses positive discrimination, affirmative action.
Article 1, Paragraph 4. It explicitly says measures taken for the sole purpose of securing adequate advancement of certain racial or ethnic groups or individuals are not discrimination, provided they're necessary for equal enjoyment of rights. It legitimizes temporary, targeted measures for historical disadvantage. Let's repeat that. Affirmative action is allowed.
But with a key limit.
A very key limit. Article 1.4 says these measures must not lead to maintaining separate rights for different racial groups. This hits directly at the old equal but separate idea, which always meant unequal. Affirmative action under ICERD aims for inclusiveness, and it's temporary. It should stop when the goals are met. Separate rights for different racial groups are not the goal. Inclusiveness is.
Okay, moving to state obligations. Article 2 sets out the core duties.
Yes, states must condemn racial discrimination and undertake to pursue by all appropriate means and without delay a policy of eliminating racial discrimination. That, without delay, is key. It's an immediate duty.
And Article 2 gets more specific.
It does. States must not discriminate themselves. Public authorities have to conform. They must not sponsor or support discrimination. They have to review national laws and get rid of discriminatory ones.
And they have duties regarding private actors, too.
Yes. A positive obligation. They must prohibit and end discrimination by private persons, groups, organizations using legislation. So the state's responsible for ensuring non-discrimination in private employment, housing, services, etc. And Article 2 encourages promoting integrationist organizations.
Article 3 takes on segregation and apartheid directly.
Head on. States must prevent, prohibit, and eradicate these practices in their territory. Federal states have to ensure their subdivisions don't practice segregation either. Repeat. Article 3 tackles segregation and apartheid.
Article 4 deals with racist ideas and organizations. This seems challenging.
It is. States must condemn all propaganda and all organizations which are based on ideas or theories of superiority or promote racial hatred. They have a positive duty to make disseminating and financing racist propaganda, inciting hatred and violence, punishable offenses. Racist groups must be banned.
And public authorities can't promote discrimination either.
Explicitly forbidden. Now, this Article 4 requirement is strong. It raises questions about tension with freedom of expression, like under ICCPR Article 19. The Human Rights Committee has a slightly different take on hate speech boundaries. But ICERD's Article 4 is clear. States must act against racist speech and groups.
Then Article 5 lists the specific rights that must be guaranteed without racial discrimination. That's a long list.
It's comprehensive, covers a wide range of civil and political rights. Equality before courts, security of person against violence, state or private, political rights, voting, standing for election, public service access.
Also key civil rights. Freedom of movement, nationality, marriage, property, thought, conscious opinion, religion, opinion expression.
And, crucially, Article 5 ensures economic, social, and cultural rights are protected from discrimination. Right to work, choose employment, fair conditions, equal pay, unions.
And basic well-being rights.
Yes, right to housing, public health medical care, social security, education and training. And participation in cultural life. Remember these ESC rights covered by non-discrimination?
Article 5F specifically mentions the right of access to any place or service intended for use by the general public, such as transport, hotels, restaurants, cafes, theaters, and parks.
That right of access is fundamental. It hits at historical exclusion from shared spaces. As the source notes, it's no accident the U.S. civil rights struggle often start with protests about buses, lunch counters, think Rosa Parks. Article 5F captures that basic need for equal access. Repeat, Article 5F, access to public places, Rosa Parks.
Then Article 6 reaffirms the right to an effective remedy through national courts.
An effective remedy, yes. Article 6.
And Article 7 stresses immediate measures in education to combat prejudice.
Education is key. Article 7. So that's Part 1 of ICERD. The definition, nuances on citizenship affirmative action, state duties, negative and positive, banning segregation and racist speech groups, and the long list of rights under non-discrimination.
Got it. Now, Part 2 sets up the monitoring machinery. The Committee on the Elimination of Racial Discrimination, CIRD.
CIRD, composed of 18 independent experts elected by states' parties. They serve personally, not representing governments. Aiming for geographical balance and diverse legal traditions. Standard treaty body setup, really.
And the main way they hold states accountable is the reporting procedure in Article 9.
State reporting, yes. Initial report within the year of joining, detailing measures taken. Then subsequent reports every 2 years. CIRD can ask for more info, too.
CIRD examines these reports, talks to the state, and issues concluding observations.
Exactly. Assessing compliance, raising concerns, making recommendations. CIRD reports annually to the UN Secretary General and can make suggestions and general recommendations on issues.
The source acknowledges problems with the treaty body system, like backlogs.
Yes, systemic challenges exist, but it stresses the system still has significant value for scrutiny, dialogue, and encouraging reform.
Articles 11 and 12 set up a state-to-state complaint mechanism.
They do. Allows one state party to bring another's alleged breach to CIRD.
How does that work, briefly?
Under Article 11, State A complains about State B. CIRD tells State B, which has 3 months to respond. If it's not resolved and domestic remedies in State B are exhausted or too slow, either state can refer it back to CIRD.
And then?
CIRD can appoint an ad hoc conciliation commission under Article 12 to investigate and seek an amicable solution. The commission reports back. CIRD sends the report to the states, who say if they accept it.
What if they don't accept?
Article 22 allows referral to the International Court of Justice, the ICJ, or another settlement method. Remember the ICJ option.
Sounds thorough, but has this state-to-state procedure actually been used?
Critical point from the source, no. It has not been successfully used to date, not to the stage of a CIRD investigation or commission. Ukraine tried to use ICERD against Russia before the ICJ, but the ICJ declined jurisdiction on the ICERD points there. So it exists on paper, but hasn't been used under the convention itself. Repeat. This procedure has not been used.
Okay. Then Article 14 introduces the individual communication procedure, and this one is in the treaty text itself.
Yes. Article 14, individual communication. Unlike most treaties where it's in an optional protocol. but it's still optional for states.
States have to declare they accept CERD's competence to receive complaints from individuals under their jurisdiction.
Exactly. Individuals alleging a violation of the convention by that state, which hasn't been fixed domestically. Key criteria: individual within jurisdiction, violation claimed, no domestic remedy.
So individuals can complain directly to CERD if their state agrees.
Correct. There are admissibility criteria. CERD tells the state confidentially. The state responds within 3 months with explanations, remedies.
And the big hurdle for the complainant.
Exhaustion of domestic remedies. You have to show you've tried everything legally available at home or it took way too long. The procedure only started working after 10 states made the Article 14 declaration. Repeat, domestic remedies must be exhausted.
The source uses Kamal Qureshi v. Denmark as an example. Communication 0272002. Tell us about Kamal Qureshi v. Denmark.
Kamal Qureshi, Danish national, MP. Alleged Denmark violated Articles 2, 4, 6 by failing to prosecute political party members for discriminatory statements and failing to act on reported incidents.
Denmark's defense.
Failure to exhaust domestic remedies, among other things, but CERD looked at it and said no, he had exhausted them. So, communication admissible.
And the substance. Did CERD find a violation?
On the merits, CERD was specific. It noted some discriminatory statements in Denmark were punished, but others at issue, referring generally to foreigners, were found not, in that specific context, to single out a group based on race, ethnicity, etc. under Article 1's definition. So, no breach found in this particular instance. Repeat, referring generally to foreigners was not found in this context to meet the Article 1 definition.
That's a fine distinction.
It is. Although CERD found no breach there, they did draw Denmark's attention to a general recommendation on non-citizens, and the source links this to the state reporting process. CERD's separate 2002 SHUG, concluding observations on Denmark, expressed broader concern about increased hate speech, urged monitoring, highlighted politicians' roles. While no direct link was drawn between Qureshi and the observations in this case, it shows how different mechanisms can inform CERD's view overall.
Okay, that clarifies part 2. CERD's structure, state reporting, the unused state complaint mechanism, and the individual communication procedure via Kamal Qureshi v. Denmark, showing admissibility and applying Article 1.
Right, so now we understand the convention and its machinery. Let's move to Section 4, ICERD in action, looking at state reporting and contemporary issues.
CERD's work has evolved, become more detailed, especially through general recommendations, sometimes called general comments.
Yes, and a key contribution is developing rights application through the prism of non-discrimination, especially ESC rights. ICERD doesn't create new ESC rights, but says whatever ESC rights states provide must be non-discriminatory. And that obligation is immediate, not progressive realization. No delaying non-discriminatory access to housing or healthcare.
CERD's general recommendations give detailed guidance, like General Recommendation number 27 on discrimination against Roma.
Exactly. GR 27 is a powerful example. It gets very specific. Guidance on basic education for Roma children, considering traveling communities, temporary classes, distance learning.
Housing for nomadic Roma travelers.
Calls for states to provide adequate camping places with facilities. Stresses equal access to healthcare, Social Security, eliminating discrimination by providers, highlights need for specific health programs, especially for women and children, given their disadvantage. These details show CERD ensuring vulnerable groups aren't missed. Remember these examples regarding Roma rights.
So the reporting system lets CERD systematically engage with states about marginalized groups, indigenous peoples, Roma minorities, migrant workers.
And the source uses the UK as a case study over time, 2003, 2011, 2016, reports to show how this works and the recurring issues.
Okay, UK 2003. CERD praised legislative changes, shifting the burden of proof, broadening indirect discrimination.
Yes, and the source links these directly to the racist murder of Stephen Lawrence in 1993 and the subsequent Lawrence inquiry. Remember Stephen Lawrence inquiry?
That inquiry was critical of the police investigation. Found institutional racism.
Famously, yes. Defined it not just as individual prejudice, but a cultural failure of the organization regarding race. Not just rotten apples, but systemic. Repeat. Institutional racism. CERD welcomed changes stemming from this. But in 2003, CERD also had concerns about treatment of minority asylum seekers and ineffective handling of hostile media by the Press Complaints Commission.
Fast forward to the UK's 2011 report. Similar concerns, but also positive steps.
Yes. CERD welcomed the Equality Act 2010 landmark legislation consolidating anti-discrimination law and the Equality and Human Rights Commission. Remember, the Equality Act 2010.
But concerns remained about media attacks on minorities and immigrants.
Yes, virulent attacks and negative portrayals. Also concerns about disproportionate police stops and searches affecting Asian and African descent groups. That's a recurring theme. Stops and searches, disproportionate impact. CERD felt it could encourage stereotyping and impunity.
And recommendations on asylum and terrorism laws.
Yes, reform recommended for laws seen as discriminatory, potentially contributing to Islamophobia prejudice against Muslims. Repeat, Islamophobia linked to counterterrorism measures.
And then the 2016 UK report.
Again, welcome some initiatives, anti-hatred, university access,
Mhm.
but grave concerns about a spike in hate speech around immigrants during the 2016 Brexit debate. Remember, Brexit hate speech.
And the recurring issues.
Continued concern about disproportionate targeting of Muslims by anti-terrorism laws and disproportionate stop and search of black individuals.
So the UK example shows CERD tracking issues, acknowledging progress, but persistently addressing ongoing concerns like media, police practices, security laws impact.
Exactly. It's continuous scrutiny and dialogue.
Looking at these reports makes the convention feel very real and relevant today. And listeners can look up reports for their own countries on the UN Human Rights Office website, www.ohthr.org, and HR body CERD page, cerdindex.achx.
Definitely worth doing. Okay, finally, let's turn to a group whose rights are critical now and specifically covered in the source: Indigenous peoples.
It's interesting the source says Indigenous peoples weren't fully envisaged as protected by ICERD initially, even though they were major victims of colonialism.
That's right. And the scale is huge. Over 370 million people, maybe 70 countries. Incredibly diverse, but share characteristics. Distinct traditions, social, cultural, economic, political systems, a strong link to ancestral lands, usually non-dominant groups. Repeat, Indigenous peoples. Over 370 million distinct characteristics.
They're the original inhabitants, maintaining distinct identities within states often dominated by later arrivals.
Yes. And there's no single official UN definition because of this diversity. Understanding relies on key elements: self-identification as indigenous, historical continuity with pre-colonial, pre-settler societies, strong link to territories' resources, distinct systems, culture, language beliefs, non-dominant status, and a resolve to maintain their ways for future generations. Repeat these elements.
Although not initially central, CERD recognized the systematic discrimination and adopted General Recommendation Number 23 on Indigenous peoples in 2007.
Yes, GR number 23. A significant step providing guidance to states under ICERD towards Indigenous peoples. Repeat, GR number 23, adopted 2007.
This coincided with broader developments, like the UN Declaration on the Rights of Indigenous Peoples, UNDRP.
A key development, yes, UNDRP, also adopted in 2007. Repeat, UNDRP 2007. Technically a declaration, not a binding treaty, but the process involved Indigenous peoples heavily, and wide state support means many see some provisions as reflecting legal obligations.
UNAPRI has 46 articles covering diverse problems. What are the core themes?
Equality and non-discrimination are fundamental. Repeat,
Sorry.
equality and non-discrimination. But it recognizes innovative approaches are needed. Collective rights, held by the group, cultural rights, and importantly, self-determination.
And self-determination here means?
Generally understood within UNDRIP, not as forming new states, but as greater autonomy and self-government within existing states. Their right to determine their political status, pursue development freely, it's about internal autonomy. Repeat, collective rights, cultural rights, self-determination, internal autonomy.
Let's look at two key UNDRIP articles the source highlights. Article 8, prohibiting forced assimilation.
Article 8.1 is clear. Indigenous peoples have the right not to be subjected to forced assimilation or destruction of their culture. Repeat, Article 8, forced assimilation. This rejects the old idea that their cultures were inferior.
And Article 8.2 lists specific prohibited actions states must prevent and remedy.
Yes, actions directly linked to past destruction. Anything aiming to deprive them of integrity, cultural values, identities, dispossessing them of lands, territories, resources, forced population transfer, forced assimilation, integration, propaganda inciting discrimination against them. Repeat, Article 8.2, specific prohibitions.
This directly counters historical policies. The source uses Australia's stolen generations as a chilling example.
A deeply disturbing example. From the 19th century to the late 1960s, Aboriginal children forcibly removed from families to assimilate them, erase their culture. Repeat, stolen generations.
The source notes Prime Minister Kevin Rudd formally apologized in 2008.
Yes, but also points out the apology wasn't accompanied by redress or restitution. Policies like the stolen generations are exactly what Article 8 targets.
Another crucial provision, Article 28, the right to redress for land taken.
Article 28.1. Indigenous peoples have the right to redress, including restitution, return of land, or, if not possible, just, fair, equitable compensation for lands traditionally owned, occupied, used, and taken damaged without their free, prior, and informed consent. Repeat. Article 28, right to redress, restitution, compensation, free, prior, and informed consent. That last phrase is key.
And Article 28.2 specifies compensation forms.
Usually equal quality-size status land or money or other redress, unless they freely agree otherwise.
Now, the significance seems huge. Correcting historic wrongs based on discrimination, on not seeing indigenous peoples as fully human with land rights.
Immense significance. Trying to rectify dispossession. Repeat. Historic wrongs, discrimination.
Yet the source notes complexities in applying Article 28.
Yes, no time limit mentioned, raising issues of proving historic occupation. What about resource-rich land like Ogoni lands? Does redress mean just other land or a share of wealth extracted without consent?
And free, prior, and informed consent regarding historical treaties.
One of the biggest complexities. Many historical treaties were coerced, at the end of a gun barrel, fundamentally unequal. Applying free, prior, and informed consent retrospectively, is legally and practically tough. Repeat. Free, prior, and informed consent. Historic treaties, coercion.
Despite these complexities, UNDRIP is seen as a massive step forward.
Enormously significant. Attempting to right historical wrongs based on discrimination, recognizing rights to culture, lands, self-determination. Though challenges remain.
We've covered a huge amount today. Started with the historical context, colonialism, segregation, the U.S. struggle, fighting denial, and inferior rights.
Then the core legal response, ICERD. Its genesis, key provisions, Article 1 definition, affirmative action, Articles 2 to 7 state duties, Article 5 rights.
We examined the machinery, CERD. State reporting, the unused state complaint mechanism, individual complaints via Kamal Qureshi v. Denmark.
We saw ICERD in action via the UK, reports tracking issues like institutional racism, post-Stephen Lawrence, stops and searches, media portrayal, Islamophobia, Brexit hate speech.
And finally, indigenous rights. Why they matter now. UNDRIP, 2007, collective rights, internal self-determination. Article 8, forced assimilation, stolen generations. Article 28, land redress-free, prior informed consent.
To consolidate, especially for exams, remember the history, key concepts, institutional racism, affirmative action, ICERD basics, Articles 1 to 7, Part 2 mechanisms, CERD, reporting, complaints, key cases, Brown v. Board, Griggs v. Duke Power, Chouette v. Coalition, Qureshi, indigenous rights, UNDRIP, Articles 8 and 28, free, prior, informed consent. Repeating these is key.
Absolutely. And remember, this deep dive was based on educational materials made available by the University of London.
And brought to you by Sinorbit Academy, Sri Lanka.
We really hope this detailed exploration helps your learning and prep. Good luck with studies and any exams.
As a final thought, consider that potential exam question from the source. ICERD was adopted to combat apartheid and is of no real relevance to the modern world. After all, we've discussed CERD's ongoing work challenging discrimination globally, its application to modern issues like policing and media, its role in indigenous rights. Why is it so vital to strongly disagree with that second part? Why does ICERD remain undeniably relevant today? Something to ponder.
Until next time, keep digging deeper.